studio. It's our pleasure to welcome now Professor Christopher Green. He's up there at the Ole Miss Law School. Professor, always good to see you, sir. Thanks for coming on.
Thanks for having me. Good to see you.
We've been talking this morning in the first couple of segments about these judges in various areas of the country that just seem to be striking down the president's orders via executive order. And I guess it's a complex legal issue, is it not, Professor, as to what authority the executive branch actually has to list out these policies and issue those policies, such as the one we've been talking about this morning. It just happened yesterday, the DEI policy, ending DEI in schools, and the Trump administration says you're going to do that. And this judge, I guess 3 judges, right, in this particular court, come out. 2 said, you can't do that, Mr. President. 1 said they were okay with it. And what I got from it, what I gleaned from the reports, Professor, and get you to comment on it, is that the judges said, well, this really goes beyond the goals, the purpose of this policy.
Yeah. So the thing is, the federal government just gives absurdly large amounts of money to the higher ed system. So Ole Miss, Mississippi State, I think at one point they might still be the 2 single entities that get the most money from the federal government. So thank you, Senator Cochran and Senator Hyde-Smith. The thing is,
within our state,
Professor? I think nationwide at one point under Cochran, just like he appropriated, sent stuff. Well, some of those have been canceled, but the thing is, there's this massive flow of money. And traditionally, there's been the feds have sort of, been more or less laissez-faire, but you have these statutes that give them authority. In theory, if you're not spending the money for what you're supposed to be spending the money on, you can cut it off. The Supreme Court really since the 80s. So we had a case about Libby Dole using federal highway funds to coerce states or pressure states, buy states, pay states to raise their drinking age. And the Supreme Court said, well, that's germane to the highway funds stuff. So you have this kind of vague sense of germaneness of funding cutoffs. And so in 2012, actually, the NFIB versus Sebelius, the big Medicaid case, they said requiring states to go back to no Medicaid at all is not actually germane to the purposes of the Medicaid situation to provide medical care. So that doctrine is basically what's going on in the background of a lot of these cases. They say they have all this Department of Education money. What is that money for? Well, a lot of it was done in 1964, implementing Brown versus Board of Education. We say, hey, if you don't play ball with Brown, you don't get this money. And then we have this question: well, what is going on with these DEI things? The words diversity, equity, inclusion. Well, you might say, well, that's just enforcing the 14th Amendment. Of course, in practice, there's massive disagreement about what that means. You look at some universities that are only kind of sort of complying with the SFFA case. So you get these executive decisions say, we're just gonna have a meat axe here. But there are some arguments that, hey, a meat axe approach is not good enough. You've got to be more tightly tied to the purposes of the statute. But I mean, as with huge numbers of these things, dang it, Congress has got to clarify this. And if they would just put in, you can have federal funding cutoffs for X, Y, and Z, and we're going to have a procedure within the executive branch, and here's exactly why you can do it. They do this in lots of statutes. Procedures for immigration law have all these the word they always use is reticulated. I mean, just incredibly complicated. And they could come up with some sort of system for these funding cutoffs so the executive decisions weren't so erratic. But again, Congress hasn't done their job. And broadly, I mean, how long have they not been doing their job? I mean, it's about 100 years. It was before the New Deal. we started getting these massive delegations from Congress, like, just solve the problems, executive branch, and then it got really big uptick in the 30s. The 50s, really, a lot of these policies start getting having a massive federal control over stuff when we just start subsidizing the heck out of everything. Because it's the 1950s. We think we're America. We're going to be the most prosperous nation in the history of mankind for the rest of the history of mankind. And they think we can just fund all this stuff. And we still are the most prosperous nation. But all these massive subsidizations of higher ed, that's one of the big things. But lots of areas started in the 50s, and thinking like, okay, how are we going to, unwind some of this? Be more responsible, not subsidize stuff in ways that really cause just the amount of federal power, the amount of executive federal power is way more than is healthy for a republic, and that's fundamentally what's going on. So I think these judges hitting back are the probably a somewhat irregular approach to a somewhat irregular tweak on a somewhat irregular system. So there's just a whole lot of this is not how it's supposed to be. I keep coming back to Federalist One. Are we really a people capable of government by reflection and choice? We're just not people who reflect enough before we make decisions. That's what the legislative body is supposed to be doing. It's supposed to be saying, okay, we think of the pros and cons. You have to make some kind of compromise, get something that everybody can live with. But instead of doing that, they just say, "Oh no, executive, you do it." And then we have these huge stakes rolls of the dice every 4 years, and it's swinging back and forth in a way that is not good for the health of the long-term health of the republic, or even the short-term health of the republic.
So two observations. The first is this test of germaneness. I mean, could there be anything more subjective than that? The test of germaneness. But I know that's what judges' responsibilities are, is to sort through all that and make some determination in their infinite wisdom, I guess. And then the other thing I think that's driven these executive orders, Professor, is something like this. You got to have 60 votes in the Senate. Unless you can figure out some way to insert it in a budget bill, which then that has to survive the test of the Senate parliamentarian. And I think that's why we've seen this rise in executive orders and feel like that we're just being governed by executive order.
Yeah, so if we could come up with a way to kind of get some of the good government-ish stuff where there's really a lot of consensus, maybe not 60 votes on the particulars, but like kind of a 60 vote threshold that like we got to do something that's legislative, that actually is baked into a statute, and somehow increase the number of things that get handled with just a 50 vote threshold beyond the emergency budgetary stuff, because we're doing a lot of the executive stuff on the theory that it's an emergency. It's not really an emergency, and we're doing a lot of legislative stuff. Well, we kind of put it in the budget thing. It's an emergency. What's emergency of your own? Your own incompetence is not an emergency. It's if I could pick all the people in Congress, or a lot of individual Congress people, I wish the institution worked differently. So you have a collective action situation, but it requires some really, really skilled people. Mitch McConnell in his prime was better at it than a lot of people, but they're just it's hurting. I mean, Trent Lott always said it's like getting these 100 people to do anything. It's like herding cats. And I've been a cat owner for a few years now. And like, man, it is even just one cat is tough. But basically, getting them to say, look, what's good for the country is really more important than being able to run ads back home and whip up your base and maybe get a 1 in 1,000 chance of you being president someday. Yeah, that's more important in the Senate than what you're doing. So it's a difficult dynamic. But if you I think rereading the Federalist Papers is great. Federalist 51 about ambition counteracting ambition. I wish Congress were more ambitious about being more zealous for its prerogative, saying, no, we get to make these rules, not these bureaucrats, not even the president. And part of the thing is, a lot of people in Congress they agree with the substance of a lot of these rules, and like, well, we don't want to smack these down, but they gotta bake in some part of it into a statute if it's going to have any lasting effect, and be independent of whether it has lasting effect. It's just, it makes it so unstable in general. So either rule, if you baked it into statute, would be better than whipping back and forth. And in the investment community, that. I mean, just, you can't make investments if you don't know what the rule is going to be.
No doubt.
5 years from now.
So we got a break right here, but on the other side of it, I want you to think about this and respond when we come back. Is okay. Had this DEI rule that the president issued in executive order, had that been codified in statute, what does that mean as far as the court's ability to act and strike it down or uphold it? We'll talk about that on the other side of the break. We got law professor Christopher Green with us. We're coming. Law professor Christopher Green at Ole Miss is our guest. So before we went to break, Professor, what about that? Had this been law, passed through the standard process, through the Congress, signed into law by the president, codified and so forth, as opposed to being done through executive order, how does that change, if at all, the power of these federal judges to act on this policy?
Well, it would depend how Congress worded it. So back in '79, we had this big case about whether you can have employers adopting, voluntary-ish affirmative action policies. Back then it was people that had, in really recent memory, engaged in really overt racial discrimination, and you're interpreting, this language from the Civil Rights Act that, on its face, really seems like it's a completely categorical requirement of colorblindness. So, so if you look, really, you would get the kind of situation you get in a lot of the Title VII cases. So the cases on transgender rights, rights of people in same-sex marriages, those sorts of things under Title VII, you'd get a lot of those same kinds of questions coming up, depending on how exactly Congress worded it. So, so if they said, you can't have the current DEI programs or stuff like that, right? Then you'd have the judges have to figure out, well, what is stuff like that? So you think, okay, don't word it like that. The Congress would have to, you get these staffers, run around, pick out a thesaurus, like come up with a word that's going to cover it. There's certain things you can do in a statute. If you said, like, okay, don't use any current materials. So you can just do a text, do a compare document. So hey, you're using the same paragraph and you're just literally replacing D with something and E with something. If that's all you're doing, so you could come up with tests like that. But it's inherently going to require judgment.
And my understanding is that's going on now. There's a lot of subverting going on where exactly what you're saying. Well, we're not calling it DEI, but still accomplishing the same goals of a DEI program. Harvard. So this intrigues me. You got the Trump administration saying, hey, you guys are looking too anti-American and you're allowing this anti-Semitism to exist in a rather profound fashion on your campus. We're pulling federal funding, significant federal funding, to this Ivy League school. Harvard's now suing. Sort that out for us.
Yeah. So again, it's this, the constitutional issue about whether, if this had been done by Congress, that would be kind of the germaneness question. So is this an asymmetrical response? And partly one of the big questions is, just what is the extent of the coddling or encouraging of anti-Semitism on campus? I've got a friend who's there who has tweeted a lot of the stuff. I mean, it really has been pretty outrageous how they've taken their standard rules about protesting in certain places and haven't enforced them. When they're being done by pro-Hamas folks, and there's particular people who are Jewish students on campus who have to go different places sometimes. there's a lot of details about individual incidents, but the if you look at the materials that are getting that have been used by these folks, it is some really, really odious stuff. And I mean, this globalize the intifada stuff is, I mean, that's basically saying we want to get Jews out of these spaces. And
so I guess the question is, Professor,
that's really bad.
Ken Harp, you mentioned earlier Mississippi State Ole Miss, huge recipients of federal dollars. I mean, do they have a right to these dollars to the point that they can sue and say, hey, no, you can't deny us this money for any reason whatsoever? Can the federal government not sort of attach strings, I guess, to this money?
Yeah, so the federal government certainly can attach strings. And really, I mean, the interpretive question, the legal question is exactly what was that string? And is a string of this, how thick is the string? One way to think of it. Is this a kind of an asymmetric response? But if you look at what they were doing in the 50s with a lot of this money, a lot of it was for almost just like this kind of thing. I mean, there were quotas on Jewish students at a lot of these universities, and we said, hey, we're not gonna have racial discrimination. Kind of the 60s statutes putting ties on these. This is kind of close to the core of what some of these elite universities were required to do, because I mean the Jewish people as a whole are high achieving people who work really hard, and if you give them a fair fight in academic standards, they're gonna maybe not wipe the floor with everybody, but they're gonna have results that look disproportionate.
We got to go. Always appreciate you coming on, Professor. Really enjoyed it. Thank you, sir. Appreciate it.
Great to see you, Gerard. Take care.
We're coming right back after Fox News and SuperTalk News.